Lord, with, re with regard to this 2 p.m. fixed matter, which your lordships are hearing, Lord, if I may just trouble your lordship once, Lord, I have on the bunch of the applications with this appeal, but I have an application number 26, which is for an addition of party. But if your lordships, my lord, if there is a ballpark idea on the applications will be taken up.
Pardon?
Well, there is an application item number can 26, which is
Remind us on the next.
lordship. Next.
Hello, am I appearing?
Which is the application?
Yes.
Which is
Number can number 26.
put a bill, put it.
One of these applications below your lordship. Item number 56. Below that, my lord, there is a can 26 of 2024. Lord, I'm deeply obliged, your lordship.
56.
26. List is na.
Fourth line.
Item number 56 है तोला है तो मतलब in MAT 873 of 20.
56 से तोला है ये कैन
लिस्ट देना मैं देखिए दीजिए.
4 नंबर लाइन है कैन.
This is in connection with which appeal?
मतलब MAT 873 item number 56.
इन अपील order
26 of 2024.
Yes.
Lord, I'm deeply obliged, your lordship.
May I please? I am appearing in my lord MAT 1873 of 2023. This was my lord was allowed on the leave to file appeal was allowed on my lord 12th October. And my lord, I am not appearing for the parateachers. I am appearing for the trained candidates who had been, my lord, no, I'm appearing for the untrained candidates who have subsequently, my lord, trained themselves. Lordship, may I just?
You're appearing in which appeal?
My lord, MAT 1873 of 2023.
How many appellants are there?
My lord, how many applicants? 30 applicants.
Yes, they are what you said?
My lord, we are similarly circumstanced 21 applicants. We are similarly circumstanced as the clients of
21 applicants?
appellants.
21.
21 candidates.
Just now you said 30.
No, my lord, 21. I stand corrected.
You joined and thereafter got training.
Yes, untrained, joined, now trained. Now, my lord, on the last
Did
of
you complete your training?
with all the other persons, my lord, my training in respect of one of the appellants is in May 2019, training certificate.
May 2019. Yes.
Diploma in elementary education. Now, on the last occasion, Mr. Shen has, my lord, demonstrated before your lordship with regard to segregation. Now, my lord, my endeavor today will be to further segregate ourselves from, my lord, the allegations made in the writ petitions with regard to the dates scam or whatever, however it has been described in paragraphs 12 to, my lord, 17 of the writ petition, 12 to 18 of the writ petition. And that has found one mentioning in the impugned order at paragraph 17. My lord, may I just demonstrate before your lordship, my lord, from the convenience brief, my lord. I'll try to segregate the TATE and the, my lord, recruitment process. Kindly takes up my convenience brief, my lord. 3 pages I'll draw your lordship's kind attention to. Page 20A is the notification of TATE. pursuant to which, my lord, everyone has appeared.
Yes.
Yes. My lord, here Lordship may kindly remembers there is a recording in the orders passed, my lord, by the Honorable Judge in other proceedings which Mr. Shane had drawn your Lordship's kind attention to. 23 lakhs has participated in these proceedings. It has been submitted by Mr. Gupta. May I just place once? That-
23 lakhs
Yes.
candidates participate.
Yes, state. That has been recorded.
In which? 23 lakhs in the recruitment
In-
process?
No,
In the
TATE 2014.
Yes.
Yes. May I just part? In continuation of the notification read with such and such,
Where you are reading?
my lord, from the notification for application for forms for TATE 2014, page 20A, 20A, from my compilation. It's 26 June 2015.
Yes.
Now, my lord, in continuation of your notification dated such and such, with the corrigendum and addendum, notification dated such and such, all concerned are hereby notified that application forms for TATE 2014 will be held on 30th August 2015 from 2 p.m. to such and such throughout West Bengal, will be available on 29/6/2015 to 4/7/2015 from the following distribution centers on payment of 100 rupees only and 25 only for SC, ST other categories. Eligibility: a person who has passed HS or its equivalent examination, 50% marks, 45% reserve categories, or has been graduated irrespective of the percentage of marks in such graduation examination from a recognized university, it is only eligible as per the aforesaid notification. Thereafter, important notes are, my lord, the TATE 2012 candidates who have already confirmed their candidature online in terms of the notification on 26/2/2014 and hold the downloaded acknowledgement receipts along with original TATE 12 admit cards must not apply. So therefore, they can participate. The persons who had participated in 2012 TATE but has failed, they can again participate. They don't have to fill up. Third is,
Failed in what?
they don't have to fill up the form of TATE 2014.
So this was open to 2012 date.
Open to persons who had participated in 2012 TATE and might have failed or may participate. So therefore, they could have again participated.
Participated in the recruitment process.
2014 TATE.
Recruitment process is this is state 2014 you are saying.
Yes,
Yes.
persons prior to this TATE 2014, in 2012, another TATE was held. So there might be
notification for
TATE
state
2014.
qualified.
2014.
What you are showing from?
My contention is that TATE 2012 candidates could have also participated and that they had to indicate that they had participated in the TATE 2012 in the OMR sheets in the examination halls.
No, so
That
how
is,
does
my lord.
So what is the significance for that?
Significance is that, my lord. Significance is that, my lord. Whatever with regard to the OMR sheets are relating to the TATE examination, which is not subject matter before your lordship. That is what I'm trying to substantiate. I will show another notification and thereafter take your lordship straight away to the order where the OMR sheets are.
What is your pleading? That this marking of training was there, etc., etc.
This is appearing from this record, sir. This is appearing from this record itself. From the
We
TATE.
don't follow your argument. Your argument is state 2012 candidates who failed. They are also open to participate in
Yes.
TATE 14.
Yes. This is as it appears. I am just placing the entire document. So therefore, my contention is that anything with regard to the OMR sheets.
Where from we will get this OMR marking you are saying? This
In the
OMR marking
written examination is only in respect of TET 2014. In the recruitment process, there is no written examination.
yes.
So the fact that OMR sheets are being considered in TET 2012, 2014, that is why I indicated the mention of the OMR sheets in this notification itself.
Where is that?
Third, TET 2012 candidates holding admit cards and downloaded acknowledgements will be able to update their respective categories, DLET training, etc. in the OMR sheet in the examination halls. My contention is that whatever OMR issues are there are with regard to TET 2014 and not with regard to the recruitment process. And another thing, a candidate who will appear in TET 2014 from any district, if qualified, will get a TET pass certificate and shall be able to apply for appointment in any district of the state. So therefore, a candidate who may participate from South 24 Parganas and passes the TET examination may be appointed in other districts also. And my lord, the district codes are there in respect of this. Kindly see there are district codes. So these district codes have been shown to your lordship. Now, my lord, kindly comes to page 34, where, my lord, the candidate who had participated qualified. Page 34, I have annexed a sample copy. Kindly see qualified. Result of TET 2014 qualified, and thereafter is the notice, page 35, from where it will appear that the results were declared on 14/9/2016, page 35. Kindly takes note of this date. 14/9/2016. And my lord, the RTI applications with regard to the OMR sheets were my lord invited. And thereafter, on 24th, 26th September 2016, the recruitment process started. Mr. Shane has drawn your lordship's kind attention to the recruitment process. I'll not trouble. Now, my lord, I'll be drawing your lordship's kind attention to the orders where this TET 2014 is being considered. I'm trying to basically segregate 2008, 2014, in respect of which several allegations have been made in the writ petition. And from this, the reference of scam may have cropped into the order passed by the honorable trial judge in the impugned court, in the impugned judgment. And I'm trying to substantiate that those observations in the impugned judgment are not relating to the recruitment process. Kindly comes to, this is the latest order which has been passed. This is the order dated 30th April 2014. Kindly sees 2004, sorry, 2024, sorry. Shantanu sheet. Shantanu sheet. Kindly comes to page 7. These are the writ petitions. These are the writ petitions which were taken for consideration. Now, paragraph 3.
These are similar to Suman and those two judges.
No, not similar to Somen and Ramesh Molli. Not similar to that. These are persons. Kindly see paragraph 3. The honorable judge has recorded. May I place one?
Yes.
The subject matter of challenge in the instant writ petitions is the teacher's eligibility test, TET, conducted in the year 2014 by the board. the petitioners participated in and have found themselves unsuccessful in the state examination. A large number of litigations in conduct of the said state examination has been raised in the writ petitions. These have been broadly recorded in the order dated such and earlier orders. Further issues have come to the notice of this court after going through the affidavits of CBI. Several applications for impleadment have been filed in the writ petitions by the candidates who succeeded in TATE 2014. Each of the said application in the connection are allowed. Leave is granted to the learned advocates for record for correction. Soft copies. I'll just skip over, my lord, paragraphs 7, 8, 9 and 10 and come to paragraph 11. The subject matter of several appeals being presently heard by the division bench of this court, inter alia in mat such and such, arises out of an order passed in WPA 21187 of 2022, Priyanka Noshkar versus the State of West Bengal, cancelling the entire recruitment process of 2016, are referred by the parties. So these were the appeals which were referred. The said recruitment process was based on result of TATE 2014 conducted by the board. In the appeals in question, the order of single bench was stayed in part. The rest of the order of the single bench was eventually set aside by the Honorable Supreme Court in SLP dated such and such by 7 July 2023 order. This is the order pursuant to which we are before your lordship. Supreme Court directed the division bench to hear all the aforesaid appeals referred to herein above. The hearing is underway, referring to these appeals that I am appearing before your lordship. It is submitted by the parties that any decision in the instant proceedings would have a bearing on the issue pending before the division bench. Thereafter, the finding. This court is, however, of the view that the propriety of TATE 2014 examination would still require inquiry in these writ petitions, irrespective of the proceedings before the division bench. So therefore, the issues with regard to the TATE are different, which are being adjudicated in a bunch of writ petition, where the honorable trial judge in Sissin is in Sissin of the, my lord, matters. In those circumstances, the court directs writ petition may list for hearing after such and such exchange of affidavits. So these are all pending.
Yes.
So therefore, any allegation with regard to the TATE are not before your lordship and is pending before another honorable single judge.
Are these persons parties to this
No.
proceeding? Then
No. They are not. They are unsuccessful persons
in TATE.
in TATE who had approached with allegations in TATE. They are litigating elsewhere. And pursuant to the results of this TATE, 3 recruitment processes have been conducted. First, our recruitment process in 2016. Where this 42,000 odd has been recruited. 11,000. 16,500, 2020. Thereafter, another recruitment process.
Then what is your argument, sir?
Argument is that, my lord, TATE 2014 is totally different. And, my lord, the allegations made in writ petition from paragraph 12, 13, 14, 17, which I will not place before your lordship, are with regard to TATE 2014 and cannot be a part of these proceedings. That is my
Who
argument.
has told? Who has said that? It is not their submission.
It is, my lord, in the
Your argument. You are saying.
in the petition they have said.
The petition they have challenged in the made amendments as regards State 2014.
Yes, 2012, paragraph 12 onwards.
State 2014 issue is still alive. That is
Before
your
a division
contention.
bench, before a single bench.
That is your contention.
Yes, it is not before this division bench.
So according to you, TATE 2014 genuinity is still under the scanner. That is what you are wanting to say.
My lord, my contention is that another, my lord, division bench, another single bench.
But we want
is in-
to know your argument.
Yes.
The State 2014 is already under a scanner and continues to be under a scanner in a pending writ petition. That is what
My
you're
lord,
saying.
my lord.
So how does that help you?
My lord, it helps
That
in view
goes
of,
against you.
no, my lord, it will not. Why I'm saying so? Because in the writ petition, in paragraph 12
Yes.
and onwards, may I just place one line of paragraph 12? Your petitioner states that recently TATE 2014 scam busted in West Bengal from several cases.
Yes.
So these submissions, these averments in the writ petition has swayed the honorable single judge to make observations with regard to the scam in paragraph 17 of the impugned order. So these averments could not have been considered by the honorable single judge. Here, my lord, the petitioners claim themselves to be TATE qualified candidates. They have not challenged TATE 2014. They cannot, because they have participated on the basis of TATE 2014 examinations.
Yes.
Am I being able to, my lord, substantiate, my lord, that this is two different things? So this may not fall within the scope and ambit of this writ petition
The
and this
present
appeal.
petitioners are all TATE 2014 qualified.
Qualified. That is my contention. Now, my lord, next contention is that, my lord, Mr. Shane had drawn your lordship's kind attention to the orders passed in
Petitioners hearing,
yes,
each petitioners who approached the court,
yes,
they were untrained but TATE qualified. But TATE qualified.
TATE qualified.
So how does that help you?
It doesn't help them also. It doesn't help me. It
So
doesn't.
your
We are
argument
similarly circumstanced. So therefore, the petitioners being TATE qualified could not have, my lord, criticized TATE 2014 examination, which they have done done in their writ petition in the averments.
all the petitioners are TATE qualified.
Yes.
And as such, they cannot take any defense against them.
They cannot turn around and say that there is a scam in TATE and all these things. That is my contention.
Mm.
Next is the sequence leading to the passing of the impugned order. Now, my lord, Mr. Shane,
Repeated thousands of times.
one order,
Still want to show.
one order which was not shown, my lord, I was there present,
Yes.
kindly takes up the compilation and straight away comes to an order which arose out of the other two writ petitions which were being heard by the honorable single judge in the month of April 2023. The hearing in respect of our matter in this writ petition was also in April 2023. Thereafter, two dates were there: 2nd April, 3rd April, and 11th April, and thereafter on 12th April, the judgment has been passed. Now, kindly sees from where this has cropped in. That is what I'm trying to substantiate. My contention would be, kindly comes to page 18. Or kindly straight away comes to page 21.
21 of what?
Of my compilation. This one that I've had.
Yes.
This is a proceedings which arose out of, my lord, an order passed by the honorable single judge in Ramesh Mullik and Somen Nandi matter on 13th April 2023. Lordship has found 13th April, and my lord, Somen Nandi is WPA 9979 of 2022, which was been analogously been heard by the honorable trial judge, and our matters were also being heard. And these orders have been pointed out to your lordship by the honorable by Mr. Shin. Now, kindly cease. Pursuant to the order, page 23. The other orders are also there. I'm just drawing your lordship's kind attention to this one. Pursuant to the order of the court dated such and such, registrar has placed an affidavit dated such and such filed by the Registrar General of High Court at Calcutta. Paragraph 5 of the affidavit of Registrar General states thus: it is stated that on such and such, about such and such, Lordship has been pleased to forward a note prepared by His Lordship in respect of annexures of transcript versions of interview in such and such, an honorable direction such and such. I'm consciously not placing the entire thing. We have considered the note prepared by Honorable Judge in respect of annexure P7 and have also perused the transcript of such and such. Transcript has been authenticated on such and such. Having considered the transcript, we direct that the acting Chief Justice of the High Court shall reassign the pending proceedings in case to some other judge of such and such. The judge to whom the proceedings are reassigned by the acting Chief Justice would be at liberty to take up all applications and may move them. So therefore, at this stage, when these matters were being heard, the first two matters where the allegations of scam are there were reassigned. And my lord, the only logical explanation of referring to the scam in these impugned proceedings would be the scam which was there and which was alleged scam which was there and was being adjudicated by the Honorable Trial Judge in the month of April 2023 in Ramesh Mulik and Shomen Nondi matter, which were reassigned. And after this order, on two occasions the matter was heard. This Priyanka Noshkar matter was heard. After this order, on two occasions, the Priyanka Noshkar matter was heard. This direction was passed by the Honorable Supreme Court on 28, and thereafter on 2nd, 3rd, and 11th May, the Priyanka Noshkar matter, which the Lordship is hearing now, was heard before the Honorable Trial Judge, and the order was passed. So therefore, the reference in paragraph.
Now what happened to Shomen Nondi and
These are pending. And
these are not before us?
No. Those are not before your Lordship. Mr. Shakko Sen on the last occasion had drawn your Lordship's kind attention to the orders by which those two writ petitions have also now been stayed by the Honorable Supreme Court.
Yes.
That is 15 July 2024 order.
Where is that here?
It is not there. It is there in Mr. Shakko Sen's my lord. Kindly Kona Shelai korata ektukhani din.
15 July.
Yes. From the last Lordship may takes up 1, 2, 3 pages. 3 pages from the last. 88, I think, page. Page 8. Yes, yes.
Yes. So those proceedings have been stayed.
Yes. Now, my lord, third submission.
SLP is still pending.
SLP, yes, might be pending. I don't have the
Yes.
current status, but it's pending. That is my instructions.
Yes, anything else?
Yes. Next is, Lordship may remember, with now, my lord, not on the merits, on the procedural part. Now, Lordship may remember, during the course of this appeal matter, I wanted to draw your Lordship's kind attention to the connected applications which have been filed in these proceedings before your Lordship. Lordship had been pleased to, my lord, laboriously go through 72 applications. Lordship it has fallen from your Lordship. Now the number of applications have now increased to 110. I think as of day before yesterday, I have been informed.
No one has addressed us on the applications.
My contention before your Lordship is that only 5 applications have been, 5 or how many applications? They are just 8 applications have been allowed, out of which the stand of the applicants in those applications, some of the applications are that they are supporting us. I'll show that. Only that can be. Now, kindly comes to page 31.
So they are wanting implement vis-a-vis the appellants.
The Supreme Court says that only the persons who are assailing the order.
Show us that.
Yes, kindly comes to, I'll just maintain the sequence. Kindly takes page 31. This is the first order. I am only drawing your lordship's attention to show the date of the order. 19th May 2023.
Allowed.
Yes. 19th May 2000.
They allowed, they have
Two
been,
applications. Two applications allowed on that day, subject to maintainability.
They claim to be similar to Priyanka or
Priyanka. Priyanka. Kindly see page 831.
Yes.
Kindly seize the date and the applications.
May.
Yes.
Yes.
This is the first order which was passed by the Honorable Justice, page 31.
Yes.
Yes.
Where is that addition?
Yes. May I just? There were can 2 and can 3 in the board's appeal. Page 31, lordship sees.
Yes.
Can 2 and can 3 were the addition of party applications.
But by those similarly who wanted to join as writ petitioners.
Might be. No applications as of today has been served upon us, board may say.
They claim themselves to be similarly situated with Priyanka or
Priyanka.
Yes.
Now, my lord, kindly sees, may I just draw your lordship's attention to the appearances in the application, or my lord, I'll just straight away come to the ordering part. Appearances are at page 32 and 33. Kindly sees at page 32 bottom is for applicants in can 3 of 2023 in MAT 873
and can 2.
and can 2.
Yes.
Now, kindly comes to page 53, which is the internal page 23 of the order.
Yes.
Third last paragraph from the bottom. Application filed for addition of parties stand allowed subject to proof of maintainability. Now, my lord, this particular order was assailed before the Honorable Supreme Court. Next page. Page 54 onwards. And this is the order by which the entire thing has been remanded to your lordship. Now kindly sees what the Supreme. Yes, yes.
Yes. Now against this appeal was prepared.
Yes. Now kindly sees what the Supreme Court has observed in the last paragraph, second last, page 62 of my compilation. Yes.
Yes.
As the controversy relates to selection and appointment of the large number of assistant teachers, therefore we request the High Court to decide MAT 890. This is Tuhin Haldar, where Mr. Kullan Bandyopadhyay was appearing. MAT 874. This is Nolin Kumar Jha. MAT 873 is the board's appeal. And again, MAT 890 has been mentioned, though it has been mentioned previously, or any other case, if any, filed by the aggrieved person assailing the order of the learned single judge as expeditious as possible. So, any other case who are assailing the order. So, that was the order of Supreme Court. In view of this, thereafter, next page kindly sees, another sets of applications were allowed in these proceedings by an order dated 4th September 2023. Two sets of applications were allowed.
Yeah, just.
Yes. Four, five, six, seven, eight.
Yes. Now in page 63.
Is the order passed in this appeal by the Honorable Justice Somen Sen, presided, division bench presided over by the Honorable Justice Somen Sen.
Which was before Justice Talukdar first.
Yes. Before Justice Talukdar first.
Now in this page 63, what has been done?
Now, kindly comes to the page 65. These are the connected applications. Can 4.
Yes.
Can 4, 5, 6, 7, 8. Lordship has seen can 4, 5. Next page are the appearances. Lordship has seen, my lord. Next page, the appearances. Can 6, 8, 4.
What you are
Now, kindly see what I'm trying to show. Kindly comes to page 79. The paragraph 72. Lordship is there in page 79.
Yes.
Kindly see the orders passed here. Can 3, 4, 5, 6, 7. 4, 3, 4, 5, 6, 7. These are applications for addition of party.
No, but can 3 was not there at page 65.
This is in respect of MAT 890. That is in respect of the board's appeal. MAT 873. There were two sets of applications.
So these were in connection with
Tuhin in Mr. Kullan Bandyopadhyay's matter.
this can 1 and 2 in 890. Yes.
Yes. These are applications for addition of party.
Similar to Priyanka.
They say so. The learned counsel for the applicants submits that they stand on the same footing as that of Priyanka Noshkar and others. Page 80.
Page 80, you are showing can 6 and 7.
No, it is from previous page 79 onwards. It is showing
Yes.
continuation.
Yes.
Paragraph 62, 63. The learned counsel for the applicant submits that they stand on the same footing as that of Priyanka Noshkar and others, under whose favor the judgment was passed by the learned single judge. We allow only one representation from the applicants to be made at the time of hearing. we only permit one counsel to argue on their behalf on the basis of the available records and not on any fresh materials. This is one set in respect of Tuhin. Now kindly comes to the next set, page 81, in respect of the appearances that I have drawn your lordship's kind attention to.
Yes.
Can 4, 5, 6, 7, 8 in MAT 873. Lordship has.
Same thing, we allow one counsel.
Yes.
And what you are trying to say?
They had mentioned these matters again. Now kindly comes to page 89. This is the order of 26 September 2023. This matter appeared as item number 4 in the list. I am carrying the list. If your lordship wants, I can show. Page 84, lordship is there.
Yes, page 84. This is on 26 September 2023.
Page 88 are the appearances. In item number 4, kindly sees. Item number 4.
Sir, what you are trying
Kindly sees what they have made the submission. This matter, 89. This matter has come at the instance of the applicants in CAN 44 such and such. In paragraph 77 of the order dated 4th September 2023, it has been inadvertently recorded that the appellants stand on the same footing as that of Priyanka Noskar and others, under whose favor the judgment was passed by the learned single judge. Factually, they are successful candidates, and by reasons of the impugned order passed by the learned single judge, their services were terminated. So they are virtually supporting us. This bunch of appellants before your lordship, counsels. It was at their instance.
So what you are saying, they cannot appear now? They
No.
cannot appear in this
If
matter?
they can appear, but they would be supporting us. They cannot say anything criticizing our appointments.
Where is this paragraph 77 of 4th September?
It's 95.
Where is the 4th September order?
Yes. It starts from
Page 63.
63. Paragraph 77 is at page 81, 82.
Very good. We shall take note of.
That is. Oh, only one judgment, my lord.
So
It is
you are meaning to say that by virtue of 8 applications were allowed, addition of parties.
Yes, this I have made a list. Only those applications which have been allowed.
Though in the application they said that they are similarly
We
situated.
don't know. None of the applications have been served upon us. As of today, so many applications have been filed. We don't know what are the
So
contents.
nobody has addressed us on the applications.
So therefore, my contention is that we have shown before your lordship
Very
as it
good.
appears on
They
the
are also then supporting your claim. What you are trying to say? No, that is absurd because they have challenged.
They have said so. They have said so. These are the applications.
Yes.
I have just made a note of the applications which have been allowed. And applications 2 and 3
applicants, they have been added in the cost title.
I don't have any instructions because we are not the main appellants. The main appellants are the board, and if
Office has never been directed to incorporate their names.
I don't think so, they have been added.
Now, only once, Mr. Firdosami, you said that you are in CAN 5.
CAN 5 is mine.
All those applications are addition of party application.
But some of our additional parties, and CAN 9 is for addition of order 41 rule 27 additional documents.
But have your names been incorporated?
Not yet. Cost title not yet amended as per subject to
Where
correction.
is the order that office should correct the cost
No,
title?
there is no such order.
So we will hear you.
Yes, yes. We just once there.
But
There is
their
circumstance
contention,
and there is petition.
My lord,
their contention as recorded will be they will be supporting us.
no, never.
That is the recording. That is the recording. That is the recording. They have not challenged.
No.
These are also in 870.
There is one difficult. One is, it is a voluminous
Yes.
brief, 44 appeals are
We
here.
all are referring to AMAT 87.
So we can, suppose you are arguing, if our judgment is pertaining to the 2016 process, question of formal addition does not arise
Does not
because
arise.
it
Does
is
not arise.
applicable to
Yes.
all.
Yes, yes. Is this matter just like my lord, APAP amendment?
Therefore, my lord,
Remember APAP amendment.
so therefore, my lord, the addition of party applicants, whatever they say, they have
Your
to,
contention is in view of that recording, they are in your favor.
and they are bound by that. It is at their instance.
Yes. Anything else?
One judgment, I'll finish. And another point is that maintainability of the applications have to be when they are called up.
When they are called on,
When they are called up to say, because there can 2 and 3, the applications which have been allowed.
no, kindly come to the Supreme Court order.
Yes,
What did the Supreme Court say?
yes, SLE.
Supreme Court says those who want to SL,
Yes.
they will be heard.
Yes. So
That is pertaining to your class of candidates.
and my lord, in view of this, since CAN 2 and 3 was allowed subject to
Where
maintainability,
is that line? Oh, those,
page 23.
no, those who are aggrieved.
Yes, page 23 of my compilation.
Paragraph.
Oh, just a minute. Sorry, my lord. Not page 23. Sorry. Page 62. Page 62. Page 62.
Page 60.
Page 62. 62.
Acha, is this the last order of the Supreme Court?
Other orders are there, but these are following this one. This is the order pursuant to which everything is being done before that. So in view of this line, CAN 2 and 3 would not be maintained, which has been allowed pursuant to the previous order passed by the Honorable Justice, Division Bench presided over by the Honorable Justice Talukdar. Because CAN 2 and 3 were allowed subject to maintainability. Now, when CAN 2 and 3 is taken up by your lordship, Lordship has to consider the
Be
point.
bound by that statement.
So therefore, anyone who is not supporting us may not. And that set of councils, they are bound by their own.
Just highlighting, you are taking a technical issue. Yes,
We are entitled my lord, to take technical issues, my lord.
all right, thank you.
Now, my lord, 2003-7, one judgment only with regard to segregation I have given. Oh, no.
এইটাতে, here you have annexed. Here
No.
you have.
This is different. 7 SCC 285. Here, a selection process conducted by the CBI was in question. 3/7/285. Things out of which this arose. Paragraph 2, the Central Bureau of Investigation for SORT invited applications on 29/3/2000 for
Yes,
filling up
we-
such and such. So this arose out of my lord.
Which para you are referring?
Paragraph 2 is the fact.
Now, what is the proposition?
Point is that
Para 6.
point would be paragraph 6 last, that there should not have been in block cancellation. There has to be a segregation.
Where is that?
Placitum D.
Placitum.
D. Applying a unilateral, rigid and arbitrary standard to cancel. Applying an unilateral, rigid and arbitrary standard to cancel the entirety of the selection, despite the firm and positive finding that except 31 of such selected candidates, no infirmity could be found. With reference to the others, is nothing but a total distress of relevance and allowing to be carried away by the irrelevance, giving a complete go-by to the contextual construction, throwing onto the winds of principles of proportionality in going further than what was strictly and reasonably to meet. In short, the competent authority completely misdirected itself in taking such an extreme and unreasonable decision to cancel the entire selection, wholly unwarranted and unnecessary, even on the factual situation found to, and totally in excess of the nature and gravity of what was at the stake, thereby vitiating, rendering such decision to be irrational. These are my submissions that there should be segregation. Deeply obliged.
Please, শোনো।
Is your lordship.
Your part?
I am for the appellants. I am in mat number 1615, serial number 82 in your lordship's daily
Yes,
cause.
yes. You are a mat
1615, lordship. 1615,
6.
1615 of 2023. Saurabh Boshak and others. Lordship, I must admit at the very outset, your lordships have been very kind and exceptionally patient.
This compliment will remain after we deliver the judgment.
I was in two minds whether I should. As your lordship has shown, is a matter of fact. In fact, I did not want to.
Come to your case, yes.
May I just say one thing, because your lordship said it. When I started my profession, Mr. Lordship, in 1615, there are 334 appellants. They're all from the district of Jalpaiguri.
They were appointed and thereafter completed training.
Yes, Lordship. The appointments of all the 32,000 were over by April 2017.
Yes.
These individuals were appointed, post all the trained candidates were appointed.
So this 32,000, this cancellation includes untrained.
Yes, that was,
Only untrained.
yes, because the impugned order
Yes.
makes a specific reference saying that in fact, let me just get to
Yes,
that.
yes, paragraph 7. Yes.
It says the trained are exempted. Yes.
Huh,
so-
tender?
The trained were not part of that order. That's about it. Yes.
No, we are asking this 32,000 is trained, untrained persons who
Untrained
participated and got the training.
Absolutely. And they were trained by 31st of March 2019,
Training was over by 31st of
2019. Because I'll just reiterate just 2 points. Lordship has heard it. After the directive principles on education was called out by Supreme Court and said right to education is a fundamental right, the central legislature came out with the Right of Children to Free and Compulsory Education Act 2009.
yes, we need not go.
Yes,
into
and
this.
so once
What is your
NCT
argument, tell
NCT
us?
gave the guidelines, then TET started. So therefore, and these are these are untrained at the time of induction, trained by 2019. Now, much has been said about the interview and the aptitude process. There are 2 things I need to point out, very specific to this case. In this 334 appellants from Jalpaiguri district, now what has come to our notice on perusal of the record, that in the impugned order, what it does not have anybody, no interviewer, no candidate, and none of the 139 petitioners are from the Jalpaiguri district.
No Jalpaiguri, no Jalpaiguri person amongst the 4 petitioners who had examined.
The petitioners,
Jalpaiguri district.
yes, and there are few other districts in the state in which the similar situation is there. No petitioner, no candidate interviewed, no interviewer
All right.
asked question by the state. And to give a quietus to that issue, Lordship, my senior Mr. Shagor Bandopadhyay, when he had appeared, he had handed out this one notification, one memo, a notice from the board. I'll just reiterate only one point in this, Lordship. This is dated 5/12/2016. Lordship may go overlive. This is a notice to the districts. Lordship may turn over to the second page. I'll forward.
Yes.
The chairman copy forwarded for information to the chairman interview board and DI of schools of the 4 districts, namely Kuch Bihar, Howrah, Purbo Mednipur, Bardhaman, for making arrangements for smooth conduct of viva voce / interview and aptitude test and scrutiny verification. Now, Lordship, I just stop here for making arrangements for smooth conduct of viva voce, public interview, and aptitude test.
Yes.
The point I'm trying to highlight, Lordship, the board goes on record, sends notice, and informs them for the purpose to the DPSC for purpose of conducting interview and aptitude test.
Yes.
That's the best documentary evidence as a candidate that I can lay my hands on to prove that point. Lordship, I'll have just two basic legal issues, though this looks very heavy. I will just Lordship in this compilations, he's handing over. It has been a tough job on my part to ensure that no repetition takes place. Lordship may come to the judgment in serial number 4, 2009 8 SAC 106. 2009 8 SAC 106. It's a famous case of R.K. Anand versus Registrar, Delhi High Court.
Yes.
Lordship may kindly come to page 120.
Which paragraph?
Para 292.
You will be relying on paras?
292, 293, 328. Then 329, 332. May I start?
Show us the relevant paragraph.
Yes, Lordship. Lordship may kindly come to the page 120 of the compilation. That is internal page number 198.
We are there.
Yes, Lordship, paragraph 292.
Yes.
The submission of Mr. N. Rao are based on two premises. One, the sting of program telecast by NDTV was of the genre trial by media. So that's my point, Lordship. Trial by media. And two, the program interfered or tended to interfere with or obstructed or tended to obstruct the proceedings of the BMW trial that was going on at the time of the telecast. If the two premises are correct, then the rest of the submissions would logically follow. But are the two premises correct? Now, Lordship comes to the para 293 when the court questions what is trial by media. What is trial by media? The expression trial by media is defined to mean the impact of television and newspaper coverage on a person's reputation by creating a widespread perception of guilt, regardless of any verdict in a court of law. During high publicity cases, the media are often accused of provoking an atmosphere of public hysteria, akin to a lynch mob. Akin to a lynch mob, which not only makes a fair trial nearly impossible, but means that regardless of the result of the trial, in public perception, the accused is already held guilty and would not be able to live the rest of the life without intense public scrutiny. I pause for a while, Lordship.
Yes.
In this case, Lordship, with all humility, as I try to understand the rationale behind the impugned order, I'm not passing any judgment on human being. I'm not passing any judgment on any individuals. I'm just trying to assess the judgment within the parameters. Now, what happens is, in this case, Lordship, the 32,000.
Yes.
The 32,000, Lordship, with absolute humility, if I may say, that in the investigation by the Central Investigative Authorities, CBI and the ED,
all right, we understand you.
No, my point is not a single one has been accused. Yes. Now, Lordship may kindly come to page para 328, 329. That is 328 is at page 126 of the compilation, Lordship. We also find that, like almost every other sphere of human activity in the country, the electronic para 328, we also find that like almost every other sphere of human activity in the country, the electronic news media has a very broad spectrum ranging from very good to unspeakably bad. The better news channel in the country, NDTV being one of them, are second to none in the world in matters of coverage of news, impartiality and objectivity in reporting, reach to the audience and capacity to influence public opinion, and are actually better than many foreign TV channels. But that is not to say that they are totally free from biases and prejudices, or they do not commit mistakes or gaffes, or they sometimes do not tend to trivialize highly serious issues, or that there is nothing wanting in their social content and orientation, or that they maintain the same standards in all their programs. In the quest of excellence, they have still a long way to go. And the next paragraph is what I'm a little perturbed with, and it reflects what happens. A private TV channel, which is also a vast business venture, has the inherent dilemma to reconcile its business interests with the higher standards of professionalism demands a profession. The two may not always converge, and then the TV channels would find its professional options getting limited as a result of conflict of priorities. The media trips mostly on TRPs, television rating points, when commercial considerations assume dominance over higher standards of professionalism.
Yes.
Page,
Okay. Anything else?
yeah, in this, just one more paragraph, Lordship. I'll just read
paragraph?
page 127 in the compilation, page paragraph 332.
Yes.
I'll just read the first sentence and leave it at that. No personal expression, but this is something which perhaps Supreme Court has said, don't do it. We have viewed with disbelief senior advocates freely taking part in TV debates or giving interviews, or a TV reporter, anchor of the show on issues that are directly the subject matter of cases pending before the court, and in which they are appearing for one side or taking up briefs for one of these sides soon after the TV show. Such conduct reminds us of.
But there is no such allegation here.
No, I'm not. I'm just saying what in the parameters of trial by media. Lordship may kindly come to the first judgment in my compilation. First judgment in my compilation, 2023, page 1, Lordship, of the compilation.
Yes.
2023, 9 ACC.
Paragraphs?
Yes, I'll just, paragraph 6, page 186.
Para 6.
Para 6, Lordship. 186, para 6. I'll skip para 6, Lordship. I'll read it out. Media reporting on matters involving Commission of Crime.
Relevant.
Lordship may kindly come to paragraph 7.
Yes.
Paragraph 7, it starts at page 120. If your Lordship may kindly come to the next page, page number 4. In a matter which implicates the culpability of the person who is under investigation. I'm cutting it short. Media reportage in manner in a manner which implicates the culpability of the person who is under investigation is liable to seriously impinge upon the reputation and personal dignity of the individual under investigation. Biased reporting also gives rise to public suspicion that the person under investigation has committed the offense, though the complicity of the accused is yet to be investigated. And
Paragraph?
para 7, Lordship, my apologies. Para 7 starts at page 3.
Yes,
The
yes.
last 2 words in that page is media reportage. Lordship may kindly come to page 4 of the compilation. Media reportage in a manner which implicates the culpability of the person who is under investigation is liable to seriously impinge upon the reputation and personal dignity of the individual under investigation. Biased reporting also gives rise to public suspicion that the person under investigation has committed the offense, though the complicity of the accused is yet to be investigated.
Yes.
And in charge sheet is submitted. Lordship may kindly come directly to the last paragraph that I would like to, paragraph 19 in internal page 7, compilation page 7.
Yes.
This is what the Supreme Court, this is 3-judge bench. It deals it like a PIL. It says it is equally important to emphasize the nature of disclosure which is made by the police in the course of media briefing should be objective in nature and should not consist of a subjective opinion prejudging the guilt of the accused. The guidelines must duly factor in. This is what I'm insisting on, Lordship. The guidelines must duly factor in the need to ensure that the disclosure does not result in a media trial so as to allow for prejudging of the guilt of the accused. Most important, Lordship, what I'm saying now, media trials are liable to result in a derailment of justice by impacting upon the evidence which would be adduced and its assessment by the adjudicating authorities. So the Supreme Court in this judgment recognizes the ill effects of prejudging an issue by the media.
Yes.
Lordship, I would now go to my next point. Lordship may kindly come straight to the judgment in serial number 7 of my compilation. Well, it's 2025 SCC Online, Supreme Court 179. 2025 SCC Online, Supreme Court 179. Lordship may kindly come to page 160 of the compilation.
Give us the paragraph.
Yes, Lordship, I will. The paragraphs that I would be relying upon is 3, 13, 16, and 68, importantly. 3,
Yes.
13. Now, this is a case, the point that I'm...
Yes.
Yes, Lordship, may just permit me just a minute to just go to my compilation. Yes. In paragraph 3, Lordship, in the middle, therefore in the case, Lordship has that. Therefore in the case, we are confronted with a conflict between the two foundational principles of natural justice. That is, rule against bias, nemo judex in causa sua, and the right to a fair hearing, audi altrum partem.
Yes.
Yes. Lordship, this is
restricted on the principles of natural justice. This does not give anything new concept.
I understand. There are two parts to it. One is you give a right to hearing and bias. So therefore, the issues are, Lordship, at paragraph number 13.
Yes.
Page 163. Whether the selection is vitiated for violation of the first limb of natural justice, rule against, and that is rule against bias. Lordship has that? Yes. The issue B, I'll go straight to the conclusion after the issues. where it is a case of violation of principles of audi alteram partem, is demonstration of prejudice necessary to succeed with the claim of violation of principles of audi alteram partem, and C, whether the breach of principles of audi alteram partem at the original stage can be cured. Very important, Lordship. At 164, issue number C, whether breach of principles of audi alteram partem at the original stage can be cured at the revisional stage. Lordship may now come to the conclusion. Paragraph number 68, Lordship.
This settled proposition, it cannot be cured.
Yes, that's about it. And it says so.
Settled proposition. Yes. Thank you, Mr. Majumdar. Yes, anybody else?
Lordship, may I just take half a moment?
Yes.
There's a Delhi High Court judge. Why-
Another judgment you want to?
No. I just want to say something. I want to say something. On a lighter side, I'll just take half a minute. In his retirement speech, Lordship, he said there's something very important. He said, when a petitioner comes to the court on a trial, the petitioner knows what is right, what is wrong, the facts. The respondent knows what's the fact. If anything is on trial, is the judges. So, Lordship, as I leave you with the onerous task, I am most deeply grateful and obliged.
Thank you. Yes. Yes, Mr. Banerjee.
The last man standing, my lord. My lord, I'll try to be as precise as possible.
Some more after you.
I'm s-
Some more after you. Not the last.
No. After me, my lord, there is.
Take a look.
Pardon?
My lord, I thought, my lord, I'll be having the.
No next day, Mr. Chakraborty. We are finishing the petitioner's argument today.
My lord, I'll
Yes,
try.
get yourself ready, Mr. Yes.
Yes, my lord. Kindly, my lord, allow me, my lord, to.
You are for which appellant?
My lord, I am appearing, my lord, in item number 64 and 97. 97, my lord, all the appellants are para-teachers.
Item number 6.
64 and my lord, 97.
So you have been briefed by both the branches.
No, my lord. My lord, I am briefed, my lord, by para-teachers. And my lord, some of the appellants, my lord, who are selling in the same boat like my lord, learned
So
senior friends
which
clients.
branch you have been engaged?
Yes, para-teachers and non-para-teachers, my lord, if I may classify in that way.
64, how many appellants?
64, my lord, there are, my lord, 165 appellants. And 97, there are, my lord, 283 appellants.
All your para teachers are TET qualified.
Yes. My lord, item number 97, all are para-teachers.
Anybody TET 2012 qualified?
No. Take
All
24.
TET.
Yes.
Yes.
Now, my lord, kindly allow me, my lord, to hand up, my lord, two, my lord, compilations.
60 action.
Possibly, my lord, I am offering the, my lord, thinnest compilation, my lord, in this matter.
No.
No. My lord, para-teachers, my lord, para-teachers, my lord, make a different class altogether. Because
That has been argued.
yes,
Mr.
Millard, I'll
Sandal
just Millard, try to be precise. Millard, I'll not repeat. Millard, this is a horizontal reservation. 10% of Millard, the total number of Millard vacancies. Millard, I just indicate what was Millard the total number of vacancies, and Millard, what should have been Millard the number of vacancies available for para teachers. 42,949 was the vacancies. So Millard,
2009.
42949.
Yeah.
So Millard, 10% of that will come to 4294. And Millard, number of para teachers Millard, who are 4294 will be 10% of 42949.
4294.
Yes. Millard, you just shift Millard one decimal towards the left hand side. So Millard is 4294.
That's approximately 43.
Yes.
No.
4,300 approximately, Milord,
Uh-huh.
4,300 if you Milord round it off.
Right.
Now, number of para teachers who were actually appointed, Milord, is 2770.
Two, seven.
70.
That
So,
is
Milord,
exceeding the 10%.
no, much below 10%. 4,294 was Milord 10%. 4,294 was 10%. And 2,700 only Milord were appointed. So, it's much below Milord. It's almost Milord half. So, even Milord, had I got Milord 0 Milord in the recruitment test,
Yes.
Milord, I had a right to be appointed. Because
if you got
Milord,
a
those,
Even if you got a
even if I got 0, had I got 0. That's Milord the rule says, that's what the law says, that's what the recruitment notification says, that's what Milord the amended notification says. Because Milord, this is earmarked. Now Milord, I can't get 0 because Milord, there are academic marks for academic
You
scores
never
and all.
get 0.
Yes.
Your academic is there. Your
Yes,
training-
everything is there. Milord, I am putting my case, Milord, to the worst possible level and to trying to argue that, Milord, for me, Milord, there is no contender. For us, there is no contender. Nobody can, Milord, allege that, Milord, is because of our appointment, somebody has been deprived. Because, Milord, the reserve vacancies could not even be filled up. And these were earmarked for us.
It is not a question of no contender. It is a question of fraud scam in the selection process.
Milord, so far as para teachers are concerned, Milord, there is no allegation of fraud and scam. I tell you, Lordship, Milord, why?
That allegation is also not there in respect of others.
Milord, so far as para teachers are concerned, Milord, these allegations have got nothing to do. Milord, I tell you, Lordship, Milord, why? Milord, the way the Honorable Single Judge, Milord, has called out, Milord, trained candidates, saying that, Milord, they constitute a different category altogether. I do not touch it. Though, Milord, according to the Honorable Single Judge, Milord, there are scams, there are etc. So many things are there.
Where is I do not touch it? Where did you find that?
Milord, that is there in the impugned judgment. Milord, before I take your Lordships to that, may I show, Milord, the rules, Milord, that deal with para teachers. Kindly, Milord, have a look at, Milord, the rules, Milord, at page 6 of the compilation. Kindly turn to, Milord, 6, it starts. Kindly turn to page 9.
Where you are reading?
Milord, from the compilation.
Compile.
Milord, need not take any other document, Milord, as of now. Only the compilation, Milord, which I just now handed over. Kindly, Milord, have a look at page 9.
Yes.
Milord, note 7 towards the middle of page 9. The state government may, by notification in the official gazette, note 7, Milord, somewhere towards the, Milord, middle, slightly, Milord, down below. Earmark up to 10% of the total posts for candidates belonging to para teachers without disturbing 100-point roster
You
as
have
not.
no aptitude test. You
I have,
no
Milord,
aptitude
teaching
test.
experience marks.
Uh-huh.
Marks, Milord, for
Teaching
teaching
experience,
experience,
that is-
which substitute, Milord, aptitude test.
That is note 8.
Yes. Milord, in the subsequent notification.
No, not so 8.
Milord, I'll take your
Rule
lordship
8,
to that.
Note 5.
Yes, correct.
You have 5 marks for
Milord, instead of having this marks, Milord, for aptitude test, Milord, I have to be, Milord, marked, I have to be assessed, Milord, on the basis of my teaching experience.
teaching.
So whether or not there was an aptitude test, Milord, that hardly, Milord, matters so far as we are concerned. Kindly, Milord, take page 11. I'll quickly, Milord, take your lordships, Milord, through
Yes, we are on page 11.
11. Milord, clause 5, subclause A. Kindly see, Milord, the mandate of the rule. It says you first segregate the para teachers. Clause A starts with, Milord, firstly, selection committee shall segregate. Then comes, Milord, the consideration of the other candidates. Secondly. So, Milord, we form a different class altogether, class apart.
Yes.
Then, Milord, kindly turn to, Milord, page 15.
15.
15. I'm sorry, Milord, page 16. 15, Milord, the notification starts. 16. This is, Milord, subsequent.
The amendment.
Yes, the amendment. And my lords were, Milord, referring to rule 8. Here comes, Milord, rule 8. 16 towards the middle.
Aptitude deleted, teaching experience.
Yes. And, Milord, this or is disjuncting two parts of the sentence, Milord, not two words only. Well, that's nobody's case that, Milord, for para-teacher, there has to be an aptitude test. Can't be anybody's case.
Where is that or here?
Milord, that or my lords will get, Milord, 4A, third line. Viva voce or interview and aptitude test, or then, Milord, a disjunctive clause status, Milord, the separate clause, teaching experience in case of para-teacher. So, Milord, this or, Milord, disjuncts the first portion of the sentence from the second portion of the sentence.
Yes.
Now, kindly, Milord, turn to the recruitment notification once. Kindly take, Milord, page 18. Milord, a further notification came on the same day. Notification number 657. 6, Milord, page 18, 1-8, Milord, of the compilation. First recital again deals with, Milord, reservation.
This is the same notification.
No.
Same date.
Same date, different notification. Numbers would not tally, Milord. Different notification. On the same date, two notifications were there.
Yes.
Kindly take, Milord, the first recital clause, Milord, first. It says, third line, earmark up to 10% of vacant posts for para-teachers without disturbing the roster. Second recital, rather, Milord, the habendum, if I may call it. Governor is pleased to hereby direct that during forthcoming, etc., 10% of existing vacant posts shall be filled up by the para-teachers. So, Milord, this is reserved for us.
How does that improve your case?
That improves my case, Milord, I tell your lordship. Milord, now, Milord, there is an allegation that, Milord, there was no aptitude test.
That you have
That, Milord, does not touch upon me.
Very good.
Milord, there is an allegation that, Milord, selection committee was not constituted. Milord, that is one of the foundation, Milord, if I have understood correctly, Milord, of the impugned judgment.
But in their case also there is a selection committee.
Milord, I will show, Milord, what was the duty of the selection committee and how could, Milord, the Honorable Singh.
Okay, but that does not distinguish you.
That
You
does not,
had a-
that's not a distinguishing feature.
Yes.
Distinguishing feature, Milord, is this.
Aptitude teaching.
Yes.
Yes.
Yes. And, Milord, reservation.
Was that line?
And
you
reservation.
just now
Yes,
said?
Milord, the on.
What did you say that line was?
Yes. Yeah, markta করেছিস? আচ্ছা।
Touching the parity.
Kindly, Milord, take. But kindly allow me, Milord, a moment's time.
Ask your junior to find out. You
Yes.
proceed.
This is in paragraph 5,
Paragraph 5.
8613.
এখানে আমার কি আছে? Para?
Paragraph 5 of the impugned judgment. Internal page 3, Milord.
Yes.
Paragraph 5. Milord, the opening paragraph. One of the opening paragraphs. During course of hearing, petitioners disclose various particulars in the website, etc., when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment are in respect of untrained candidates at the time of recruitment who were given appointment in 2060 recruitment process. And at the same time, it was made clear that they do not have any grievance in respect of the trained candidates who were trained at the time of the recruitment and were given appointment in 2016. And the Honorable Single Judge accepts that.
No, where is that exclusion of para?
Then, Milord, the sentence that starts with therefore. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter.
Where is
Well-
para teacher out?
Milord, my submission was the way, Milord, trained were excluded.
That is
If
your
they form, Milord, a
submission.
different category,
Entered a line which we didn't get in the order.
Milord, that's the line which says that, Milord, trained are not being
They are not being touched. You said that.
trained are not being touched, Milord. That's
No,
what,
no,
Milord.
para teachers are
No,
not.
no, 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 Milord. My submission was The Honorable Single Judge said trained are not being touched. If Milord, on the Milord justification, on the reasoning, on the logic that Milord trained form a separate class, there is no allegation. Milord, if that be so, then Milord against para teachers also there is no allegation. Para teachers Milord also constitute a different class.
No, you para teachers are also have to undergo training. TET 2014, they have to appear. So
Milord,
that does
TET
not exclude them on
Milord-
the basis of these three sentences.
Milord, this TET 2014 is for all.
Exactly. You
So,
are
Milord,
saying
if
that when you
today-
have mentioned trade, we need to construe that para teacher is not within the ambit of this. This, sorry, we do not find.
The para
Line is not there. That para teachers are not, we are not touching the para teachers.
No, Milord, my submission was, Milord, I'm sorry, Milord, I could not, Milord, clarify myself. Milord, the line was that, Milord, the trained are not being
So
touched.
you are also trained. Para teachers are also have.
Now, Milord, we are all trained and within the time, Milord, stipulated by, Milord, the last notification. Now, all of us are, Milord, trained. Milord, we are no more, Milord, para teachers. Now, Milord, we are
So
trained
you
teachers.
You were untrained at the time of selection.
Correct.
So that is why they are saying at that juncture, court says trained are outside this. That will suggest the trained persons who are not the untrained candidates. Untrained includes primary teachers as well as para teachers.
Milord, I was trying to, Milord, fathom, Milord, the logic. Milord, if today the selection process, Milord, as a whole, Milord, as Milord, they were trying to allege, Milord, is bad in law. Then, Milord, how, Milord, a group of persons, Milord, can be segregated, can be, Milord, kept untouched. Milord, if selection committee, if the allegation is that the selection committee has not been constituted.
Your next point.
Yes,
What is
Milord.
your next point?
Now, Milord, on the point of, Milord, delay and latches. That, Milord, they are all untrained. None of them is trained. So, Milord, they are not assailing, Milord, trained candidates. Likewise,
There are
Milord,
no para teacher.
no, there was no para teacher, Milord, as a
Say
petitioner.
that. Yes.
So, Milord, they could not have had, Milord, any sort of allegation against appointment of para teachers first. Milord, on Milord, this delay latches, Milord, I just add one point. Milord, I'm sure, Milord, that has been argued also. I say it's not, Milord, only about the delay. Milord, the moment, at the material point of time when the writ petition was filed, Milord, they had seized their right even to be considered for appointment.
This has been argued. Sir.
True. And Milord, the judgment, Milord, of the Honorable Division, Milord, Supreme
Because
Court.
2 years training completed 2009.
Correct.
That
Correct.
is your.
And Milord, 2022, they Milord, came up with the writ petition. So by the time they had lost their right. So Milord, here there were some petitioners, Milord, who were nobody, could not have, Milord, even raised any grievance. Could not have had, Milord, any locus, Milord, to even raise an allegation. And this was not by of a public interest litigation. This was an adversarial litigation for establishment of their purported right.
Yes.
Now, Milord, from Honorable Justice Mitra, Milord, a query failed, Milord, if I could understand that correctly, Milord, even if I, Milord, why did I say that, Milord, even had I got 0, Milord, I could have been, Milord, appointed because there was no cut-off mark, Milord, for the para teachers. So irrespective of, Milord, whatever I get.
No cutoff for anybody. No cutoff for anybody.
For the para teachers, Milord, there is no cut-off mark.
No, for the untrained also no cutoff.
No. Milord, that was the reason, Milord, why I submitted this. Milord, there was a number of vacancies available for us. The total number of us was much less than the number of vacancies available. So, Milord, our appointment was otherwise automatic. Now,
You cannot say automatic. You cannot say just because there are vacancies, I will include incompetent person who got 0. That is the discretion of this.
Milord, my competency was, Milord, decided by the Milord, assessed by the selection committee. Milord, I'll take now your lordship, Milord, to that particular rule. Kindly, Milord, have a look at Rule 7. My lords will kindly get, Milord, Rule 7 at, Milord, page 9 of the compilation. Rule 7, Milord, deals with selection committee.
Rule 7.
7, Milord, at page 9, bottom.
Yes.
Milord, kindly take Milord, Rule 8. Rule 7 says, Milord, how a selection committee is to be constituted. Then, Milord, kindly comes to Milord, Rule 8 that deals with, Milord, the function of the selection committee. Kindly see, Milord, the restricted function, limited function of the selection committee at Milord, subclause 2, subrule 2 of Rule 8. The selection committee shall call all qualified candidates as mentioned in subrule 1 for the viva voce or interview and aptitude test. And Milord, subrule 1 says selection committee shall make prima facie scrutiny of the duly filled in application forms submitted by the candidates having qualification as mentioned in Rule 6. So, Milord, what the selection committee was supposed to do is, Milord, to see whether, Milord, we have produced all the testimonials and, Milord, whether we, Milord, have the qualification. Now, Milord, qualification means, Milord, DLED, and, Milord, for those who do not have it, after, Milord, all the trained candidates are, Milord, appointed, rest of the, Milord, vacancies should be filled by the untrained candidates, subject to the condition that within a particular time, Milord, will appoint, Milord, will get, Milord, the qualification. Now, here, selection committee's, Milord, role was limited to the extent of, Milord, this scrutinization of, Milord, scrutiny of testimonials.
Yes.
The Honorable Single Judge came to the conclusion that selection committee was not there. So, Milord, that was something which was not in accordance with the rule. But having, Milord, decided that, having observed that, Milord, the Honorable Single Judge said, let us, Milord, again, Milord, do the interview and aptitude test, Milord, de novo. Milord, this aptitude test and, Milord, interview are, Milord, of those candidates who have been.
In the order.
Yes, there are directions,
That
Milord, for
there
that.
was no selection committee.
There is, Milord. There
There
is, Milord, a finding.
Paragraph 16.
Yes, Milord, I'm grateful to your Lordship. Now, Milord, if there was no selection committee, Milord, the automatic inference, Milord, ought to have been then that, Milord, the testimonials are again to be scrutinized. Then, Milord, the testimonials of the trained, Milord, are also to be scrutinized. They cannot be left, Milord, untouched. Milord, the interview, viva voce, aptitude test, those are, Milord, the duties of the interview board. So, on one hand, Milord, the Honorable Single Judge is saying there was no selection committee. Then, Milord, he is leaving, Milord, the trained candidates aside, saying that, Milord, testimonials verification is fine. Let us start with aptitude test and, Milord, viva voce or interview. So, Milord, these are, Milord, in my most humble submission, Milord, are conflicting, Milord, contradictory, Milord, observations. Cannot, Milord, parallelly run, cannot run together. Then, Milord, subrule 2 of Rule 8, it says performance of the candidates who will be called for viva voce or interview and aptitude test shall be assessed separately by the interview board. That is exactly what has been done. And, Milord, subrule 8 also suggests, subrule 8, Milord, Rule 8, subrule 2 at page 10 of the compilation.
Yes.
Milord, it says this aptitude test, viva voce, interview, all these are to be done, Milord, by the interview board. And if, my Lord, looks at the construction, the language in which subrule 2 is couched, it also indicates that, my Lord, aptitude test and interview will happen, my Lord, will take place simultaneously, together. Kindly see, my Lord, the language in which subrule 2 is couched.
That is exactly that is done. Interview.
And, my Lord, the Honorable Single Judge, my Lord, was of the opinion that, my Lord, no aptitude test took place. My Lord, I'll show from the notices, the notifications.
Your argument subject to correction. Paragraph court holds that there was no selection committee.
Correct.
If there is no selection committee, you are sending it back to the self-same selection committee. Paragraph 23.
Correct. And, my Lord, you are sending it back at a stage. You are sending it back to a stage when, my Lord, the duty of the selection committee was over.
That may not be there because
Yes,
court has
it seems to be so.
no.
It clearly appears, rather, Milord, to be so. The Honorable Single Judge has not directed re-verification of the testimonials, which was the duty of the selection committee. So if selection committee was not there, then who verified? And that was never the allegation that the verification was wrong. So remember Isaac, I'm sorry. Rule 2 says that this will happen, aptitude test and interview will happen simultaneously by the same board. At the same time, by the same board, by the same group of people. And that was the requirement of law.
Yes.
Then kindly take the notifications that by which or the notices by which the candidates were called on for viva voce and aptitude test. Kindly take one sample notice. Page tab also. Page 43. Kindly take page 43 of the compilation. This was the notification. Evidence active to mark. Now kindly see the notification with the language of the notification. Second line. The recruitment process is in full swing for conducting scrutiny, verification of the testimonials and viva voce interview and aptitude test. Qualified candidates, those who have submitted online application, etc. are hereby called upon. The time, venues for scrutiny of the documents and viva voce and aptitude test of a particular district or council would be notified in the website. So, these group of petitioners, writ petitioners, they knew the rule. They knew that this is to be held simultaneously, and this is being held simultaneously. Then they made a hue and cry that there was no aptitude test.
Yes.
If kindly turn over the page, the next document, at page 44 of the compilation, this was shown to your lordships. Is individual call letter. Says the same thing that a candidate is being called on not only for viva voce but also for aptitude test. Strictly in adherence to the requirement of Rule 8. Well, single judge relied on the testimony, if I may at all call them testimony of 4 witnesses, 4 persons. Let us not call them witnesses. 4 persons who were from 4 districts: Hooghly, Uttar Dinajpur, Cooch Behar, Murshidabad, which are referred to in the impugned judgment.
7 petitioners were examined.
They are not petitioners. They were members of the interview board.
No. The candidates.
Correct.
7 candidates were called. And how many interviewers?
4.
3 interviewers, 26 petitioner candidates. 7
No.
plus 19.
Interview was taken of how many interviewers? By the not say interviewers, but how many the judge examined how many interviewers?
Plus 30 number of interviewers.
There is a chart. There is a chart given.
Judgment.
Yes, there is a chart given.
But they were not from all the respective districts.
Not from all the respective districts.
5 districts. Names were given by the board.
And selectively they are chosen. Now, my lord, kindly have a look at, my lord, the Honorable Single Judge was of the view that, my lord, this is an exercise under section 165. Kindly, my lord, have a look at the language of 165. My lord, 165 says parties. My lord, kindly just keep this in mind. My lord, I'm not troubling by reading it out.
On
Kindly, my lord, have a look at this.
evidence at
It says, my lord, parties and witnesses of parties. My lord, I being a judge, my lord, with my lord, the deepest of respect, possibly I don't have, my lord, the jurisdiction, my lord, to choose a person who is to be examined as a witness. My lord, if I as a party, my lord, choose one witness, the Honorable Judge, my lord, can examine him under section 165, but cannot, my lord, possibly choose someone to be a witness when not called upon by a party to the litigation.
where is the bar in 165?
My lord, kindly have a look at the language. And my lord, I am, my lord, fortified by one or two decisions. My lord, I'll just indicate, my lord, the citations. The
Yes,
judge may my lord, hand up on. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant and may order, etc., etc. But these persons were neither parties nor witnesses produced by parties. My lord, who can be called upon as a witness is not possibly, my lord, within the domain of section 165. And then kindly take the second proviso, last line.
now where do we get that?
My lord, let us, my lord, read once more, my lord.
Yes,
The judge may,
yes.
in order to discover or to obtain proper proof of relevant facts. My lord, I'm not on the relevancy of facts. My learned senior friends, my lord, have argued that. Ask any question he pleases in any form at any time of number one, any witness,
Hmm.
number two, or of the parties.
No, no, witness is the general term. There it is not that the witnesses brought by the party. It is not like that.
My lord, possibly, my lord, that is the only
It
possible
may be your
interpretation.
argument, but
Yes,
that does
yes.
not shut away to judges. This is a where the judge, the argument has been the judge cannot act as the prosecutor. To that
Cannot,
effect
my
they
lord,
have-
yes.
Yes.
Now, kindly have a look at, my lord, second proviso. My lord, the last sentence. Or, my lord, the last part, rather the last part of the last sentence.
Yes.
Nor shall he dispense with primary evidence of any document, except in the cases herein before accepted, my lord, those deal with sections 121, 131, 148, 149, those have no manner of application here. So, my lord, primary evidence, documentary evidence always has primacy. My lord, the honorable judge or the learned judge calls upon someone, my lord, puts, my lord, 2-3 selective questions, then asks him, my lord, to get down. And, my lord, that testimony cannot prevail over, my lord, what surfaces from the documents. My lord, here there were documents to show that, my lord, aptitude test had been held and, my lord, marks were given. So, my lord, this primacy of documentary evidence,
Aptitude test was held.
my lord, the call letters,
All letter
My
is
lord,
the
the-
invitation to
my lord, the
judge.
mark sheets, my lord, given, my lord, by the, my lord, interview boards,
Where do we
showing
get
that, my lord, those documents have already been shown to your lordship.
No,
Yes,
it wasn't shown.
my lord, those have already been shown, my lord. That's why, my lord, I am not repeating.
Maybe we have missed. Dekhi wait karo.
My lord, those are primary documents.
Wait. Which one, Mr.
দাদা ওটা
Dev?
কোথায় আছে একবার বলো তো
Affidavit used by, on behalf of the petitioner, there is a Shoykot Chalis, the name is, yes, for that.
This one.
Yes.
This one.
Possibly, see the tabulation of mark.
এটা দেখাও বের করে দিই, প্লিজ প্লিজ সরোজ।
বিশ্বনাথে। It starts from my lord.
Got it? Got it?
My learned senior friend knows this matter, my lord, like the back of his palm.
The headings. Aptitude marks before that, 1, 2, 3, 4 from the right hand side. Aptitude.
No, that is the marks given.
Marks awarded.
Mr. Banerjee was arguing that there are materials on record to show that aptitude test was held by 3 interviewers like that.
My lord, yes.
Marks
My
were
lord, this-
given. These we have seen. Marks were given.
So, my lord,
your
marks
argument
given, my
when
lord,
marks has been given.
my lord,
There
that
must
lead
have
us
been
to
an
an
aptitude.
irresistible conclusion that, my lord, the test was held. My lord, here is someone, my lord, who has
Mr.
come.
Banerjee, somebody else may put in the marks. Who knows?
My lord, then, my lord, will be taking our case too high on presumptions.
You think it is a low case? It is
My
interfering
lord,
with
this is
the
then, my lord,
candidates.
and my lord, this is an unfounded presumption. There is no foundational basis
So
of
it
that.
cannot be, you cannot make this argument that there was material on
My lord,
record
to my
show.
humble understanding, my lord, this is, my lord, a
That may
material.
be your argument,
Yes,
but
my lord.
you,
Yes.
your contention is that the notification calling for interview and the marks depicted would lead to an irresistible
Conclusion that,
that
my lord,
aptitude
aptitude
was-
test has been held. Now, my lord, what is an aptitude test, my lord, is defined. It's not, my lord, necessarily a chalk and talk method. That, my lord, I have to be taken, my lord, to the classroom. My lord, I have to demonstrate something in the classroom. Because,
that Mr. Mitro has argued
yes,
that
because
the-
that is
how
not,
the education is transmitted through
yes.
material.
My lord, in my compilation, my lord, I have, my lord, annexed, my lord, some literature. My lord, what an aptitude test for a teacher means.
আর বলতে হবে না, একটু বলো।
My lord, those are there. My lord, I have marked those. My lord, I am not taking your lordships through that. My lord, I have indicated what an aptitude test for a teacher means, and that has, in our case, it has a statutory definition also. My lord, aptitude test, my lord, is defined. My lord, under the rules. My lord, rule 2C. My lord,
Yes.
when my lord, learned judicial officers are appointed, my lord, in my lord, the subordinate judiciary, my lords take aptitude test. Never, my lords, take, my lord, the candidates in a court of law, make him sit, my lord, in a seat of judge, and my lord, takes the aptitude test. My lord, it's all, my lord, in closed door. Now, my the honorable single judge was also of the view that, my lord, this aptitude test, viva voce, my lord, in one table, my lord, at one go, my lord, how can, my lord, marks how could marks be given, my lord, by the interview board? My lord, two decisions on this. My lord, just kindly take note of, my lord, the citations. My lord, one is 2015.
You have given here.
Yes, my lord. No, my lord, I'll sub. 2015, volume 11, Supreme Court cases, page 493. Paragraphs, my lord, 19 and 20. My lord, this judgment relies upon, my lord, Leela Dhar. My lord, sir, my lord,
Yes.
aware of these two judgments. My lord, Leela Dhar is 1981, volume 4, SCC, page, dada, 159, paragraph 8. In both these two cases, my lord, there was an allegation that the interviewers, my lord, clubbed marks. My lord, they did not, my lord, allot marks, my lord, properly. My lord, the honorable, my lord, Supreme Court was of the view, my lord, that cannot be, my lord, the court's business, my lord, to look into that. Because, my lord, it is best suited for the employer to decide, my lord, how they would, my lord, see whether, my lord, the candidates fulfill the qualifications or not. It's, my lord, best suited for an employer to decide, my lord, the requirements of a candidate, means the requirements of a post so that the candidates attain the threshold of the eligibility. It's not the courts look out to see whether interview and aptitude test could have been taken together, marks could have been given together, whether this could have been clubbed or not. It was like I was trying to find a fault in the process.
In Leeladhar Vichardi
The
paragraph,
Leeladhar paragraph 8.
para 8.
8 minute. And in Pradeep Kumar Rai, it's 19 and 20.
Thank you.
Now, these writ petitions, out of which the writ petition out of which this appeal has arisen, was also barred by res judicata. Because of Honorable Justice Hiranmay Bhattacharya's judgment, because of the judgment.
5 persons are common.
Yes. Yes.
Yes.
And the same allegations were raised, that has been shown to your lordships. And even if the same allegations were not raised, then this would be barred under order to rule 2, which was available, was not argued. So constructive res judicata, if I may say. So it's barred by order to rule 2, by res, by constructive res judicata. Firstly, this was argued. Even if I assume for the sake of argument that this was not argued, that was their choice. Don't all based on a suspicion which is unfounded. I do not call it wild. It's unfounded.
Yes.
Now, coming back to 165, section 165, there is a judgment of Court of Appeal. I am told that has been relied upon by Mr. Mitra.
By Mr. Anindra.
By Mr. Mitra.
Jayanto Mitra, no?
By Mr. Jones. Oh, this is Jones versus National Coal
Yes,
Board.
yes.
My lords have taken note of that. One more decision of our High Court, that relied on Jones. Reported at 2022 SCC Online, Calcutta 3991.
2022. 2022.
SCC Online, Calcutta 3991. On the proposition that the Honorable Court should not don the role of a prosecutor, should not leave the mantle of a judge, come down from his seat.
Which was relied upon.
I am told that has been relied upon. Jones have been relied upon. May I hand up 2 copies?
Paragraphs.
Milord, last 4 pages.
Jones was relied upon in another matter which was shown.
Milord, kindly then, Milord, take the trouble to have a look at this. Jones versus National Coal Board.
No, that we have that.
Oh.
Jones we have.
And Milord, this Calcutta High Court decision, Milord, division bench decision. Calcutta High Court টা হচ্ছে West Bengal Board of Primary Education. Milord, I'm told that has been relied upon. Milord, I am not then Milord repeating. Now, Milord, so far as para teachers are concerned, Milord, I would be failing in discharging my duties if I do not indicate one order, Milord, passed by Milord's predecessor honorable bench. Milord, that order was passed on 19th of June, Milord, 2023 at page 166 of the compilation. Milord, I have a duty, Milord, to show that.
No, sure. Tell us which paragraph of this 3991.
Oh, achha. Milord, that has been Milord relied upon. My lords have taken notes. So,
No,
Milord, let us not
but
repeat.
still give us
Wait.
3991. Which paragraph you are saying?
Milord, kindly turn to paragraph number. Milord, kindly turn to page Milord 47. 47. Milord, the page numbers, my lord, will get Milord at the top on the left hand side.
47. Yes.
Milord, from the very first line, Milord, the discussion starts.
What is the true role of a judge? Where are you reading?
Milord, page 47, Milord, of this
Yes.
bunch. Yes. My lord will kindly take the powers of the court to take evidence under section 165 have been discussed in Ramchandar. Ramchandar in turn, Milord, relied on Jones. And Milord, discussion starts. Then my lords will kindly turn over the page. Kindly take Milord towards the middle of the next page. Jones, Milord, is quoted.
Yes.
Yes. And then Milord, the ultimate conclusion. Page 1. Page number, ultimate conclusion. Page double. But kindly allow me a moment. Stay, Milord, my learned junior will assist me in doing that. Last paragraph.
Yes.
It any that. Milord, I just indicate Milord the concluding paragraph. Before I Milord finish, kindly take Milord 166 of the compilation. Milord, this was an order passed, Milord, in these appeals, Milord, on 19 June 2023. Kindly, Milord, turn to the order starts at page 166 of the compilation. Kindly, Milord, turn to page 175, running page 175, internal page 10. Milord, the Honorable Division Bench was of the view that, Milord, these para teachers, Milord, they may, Milord, go back to.
Also stayed by Supreme Court. The second part of the order.
Yes. But Milord, there was an observation.
State cancellation allowed the second part. Supreme Court stayed first, then next the second part was also stayed.
Milord, I'll take your lordship, Milord, to that Milord Supreme Court order.
No,
But yes, that was.
What you want to show?
Yes, Milord, the Honorable Division Bench was of the view that Milord, these para teachers, if they choose, they can go back, Milord, to the learned single judge and Milord ask for a clarification whether Milord, the impugned judgment, Milord, touches upon the para teachers or not. Because Milord, they are lacked clarification. That was the Milord view of the Honorable Division Bench.
Sure.
Page 175.
Yes.
Therefore, again, to this mind of this court, although arguable points have been raised, Milord, this was with regard to para teachers. Kindly take it from me. It cannot be presumed that at this operative order, Honorable Single Bench treated only the aptitude test and not the interview process. The para teachers claiming to be a part of the interview alone on the basis of the recruitment rules to be videographed, etc. Accordingly, at this stage, until the Honorable Single Bench is given an opportunity to clarify its stand, this bench stands precluded from treating the operative part of the judgment to be of a nature that automatically excludes para teachers. In the backdrop of the discussion, the appellants are permitted to approach the Honorable Single Bench for appropriate clarification of its judgment. Milord, after that, Milord, an application was filed, Milord, before the Honorable Single Judge, but Milord, in the meantime, Milord, the Honorable Supreme Court's Milord judgment order, Milord, came.
Application.
Milord, seeking clarification. The view that, Milord, there was something wrong, Milord, in the interview, because, Milord, someone who did not, Milord, do well in Madhyamik or higher secondary, Milord, did wonderfully well, Milord, in interview or aptitude, in interview or viva voce test. Now, Milord, if the Honorable Single Judge was of the view that, Milord, one must, Milord, procure proportionate marks, Milord, in the written test and also in the viva voce, then, Milord, there is no need, Milord, to hold viva voce. Because, Milord, my performance in the written test will suffice, because I'm supposed to get, Milord, as a thumb rule, proportionate marks in interview. Milord, these are all, Milord, presumption and guesswork.
Yes.
So, Milord, in my most humble submission, Milord, the judgment, Milord, impugned, Milord, lacks, Milord, logic. Lacks, Milord, reasoning. Milord, kindly, Milord, set this judgment, Milord, aside.
Thank you. Yes.
Milord, these are, Milord, my most humble submissions. Grateful to you, Lordship.
Yes, Mr. Where is Mr. Bian? Yes, Mr. Chakraborty.
Conclude, my lord. Your lordship was finding that what is the materials that no aptitude test was held, but some materials were, my lord, used by the petitioners in support of their contention. Aptitude test was not held. My learned senior has argued, but I was not taking any chance. My learned senior has argued that they have used fabricated documents. May I show, my lord, those documents where from it was, my lord, taken that no aptitude test was taken? They have used the documents of 2014 selection test.
Mr. Devarman, you will be having a reply. If anything want to point
On
out-
record, my lord, they have used 2014 selection. Admittedly, at that time, no aptitude test was, my lord, there.
Yes, Mr. Chakraborty, anything? Yes, Mr. Chakraborty. You are also there.
Yes, my item is 92. Item 92, my lord, Dipankar De Mondol. My lord, the appellants are the members of the All Bengal Primary Teachers Association, ABPTA, not ABTA, ABPTA, my lord.
No, the association is before us, or the individual.
No, individual. Then members they have, I have stated. Yeah.
That is what is the
My
appeal
lord,
number? What is-
I will take only 5 minutes.
what is the appeal number? Tell us.
Appeal number to the Appeal number is, my lord, 2188 of 2023. 2188, MAT 2188 of 2023.
সামনের সপ্তাহে
2023, my lord.
Yes, Mr. Chakraborty.
My lord, Dr. Devipal used to say one language, my lord, favored child. And I say that, my lord, those are selected 32,000, all are not favored child.
Some are favored.
I don't know whether any corruption or not, I'm arguing in that, my lord. But all not favored child, not asked for the favor.
How can you segregate them?
Yes, that question will come, my lord, I will reply. My lord, total marks 50, my lord, I've lost knows it, even I am repeating it, my lord. Total marks 50, and for training 15, that is out, 35. My lord, TET 5, education 15, and interview and extracurricular 15. Total 35, my lord. But those who have done well in TET and in academic career, their position in much higher than those are the not good academic career. So, my lord, in interview, only in the hands of the person's interview. In every district, my lord, there are some students, they are academically well. The selection committee bound to select them, because in selection committee, not all are the political persons.
Pardon?
Not all are the political persons, my lord. My lord, Lordship knows earlier days, my lord, in Panchayat, political persons, not our political persons. Only chairman is the political persons there. And others are the brokers. Broker does not compromise with always not compromise with the political persons, because their service, they have to answer before the court. They are very scared about these persons. My lord, interview, my lord, in interview, those who are academically high, my lord, and not ask for any favor, from interview result you will get there.
Yes.
In interview result diagram. So, my lord, interview result, you will also see two types of marks given. If you lost 6 is the 8. Somebody has given 5 and above, and somebody has given 5 and less than 5, even 0 there. Even they have to select that person. Even those who got interview 1, they have to select that person, because due to their academic career and their result in TET.
Now, what you are arguing then?
And that is my submission, my lord. All are not the favored child, not asked for any favor. This is my submission, my lord. In that circumstances, my lord, those who are academically well, those who got the better marks in written test and aptitude test, my lord, whether they will be punished, saying that you are also favored person, favored child. This is my respectful submission, my lord. Out of 32,000, in every district, losses will find that not all got the support of the interview board, but they have to select. If you go to the interview result, my lord, score sheet, lawsuit will find it. Those who have got below 5, below 4, below 3, even them they have to select. They have to select because their academic career, because their brokers did not compromise with them.
Yes.
Only chairman is the political person and others are not, my lord. And losses can remember in Panchayat service, my lord, there is a selection of the Panchayat Kurmi, Gram Panchayat secretary. SDO is the chairman, BDO is the convener, and Panchayat Sabhapati, he is political person, he is also member there. So 2, 3, 4 persons are there. If you see that time it is found that the Sabhapati, who is a political person, he is giving 10 and somebody is giving 1. But those are officers, WBCS officers, they have not done it.
Yes.
So in that circumstance, my submission that whether those who are academically well and does not ask for any favor, not have taken any favor, whether they will be punished, my lord. And then I say, my lord, about 5% will be there, 5 to 10% will be there. Those who have not asked for any favor from any person. Anyway, and there the, my lord, I'm saying all not come to as under the because we have not collect the but there are many persons, they are saying that we have not asked for any favor. Whether they're corruption or not corruption, I'm not going there.
All right. Thank you.
So, my lord, this is my submission, my lord. Those who are not academically well, justice kindly think for them, my lord. I'm not submitting about Supreme Court judgment. I'm not submitting about the merit of the writ petition, whatever it is. I'm not assessing the judgment of the Honorable Trial Court, my lord, because I'm submitting this because all are not get opportunity to get submit before the trial court. Trial court. That is my submission. So, my lord, losses kindly think. Here, my lord, some appellants, their honors graduate, MA graduate, honors in mathematics, honors in mathematics, MA in Bengali, honors in Bengali. They are also selected. I asked them why you have taken this service. Well, tell me where there is a service. And this post, my lord, nothing but just above the peon. Just above the peon, a primary teacher's post is just above the peon or the group D staff. So for this academic, those academic year, they have selected without any favor. They are not the favored child. This is my submission.
All right.
My lord.
Thank you. Yes.
Huh?
Yes, yes, Mr. Biani, which is your application? You are supporting whom?
No, I'm not. But I'm neither supporting anybody nor. I tell you.
Then what exactly you want?
There is an application for addition of party in 92. Amala losses can you say 90 item 92.
Addition of party.
Possible said that in the final judgment. Possible.
What is your application number?
Can 3 there? Can 3 is there?
Can 3. This was filed by whom?
Some party man. They are also member of the ABPTA.
You are representing them.
No, I'm not. One of them, my is it there? Is appellant.
My lord, 92 appeal on my learned senior friend, and my lord in 92, my lord there was a can 3, my lord filed by the identical
2188. 2188.
Item 92.
Oh, huh.
My lord, identical person of the appellant filed the my lord can application.
They
Among
are selected
32,000.
persons. They are selected.
Among 32,000.
So what is it? We have heard you. Can 3.
Can 3 file my lord long before because this is my lord
No, you have not been, your application, your names have not come in the cause title of the matter.
No, my lord, can 3 is there, my lord. Can
3 may be there, but kindly there are more than 100 applications filed. So only two
when
persons-
my lord, the all additional party I had, my lord, lordship will allowed
we have
in the
heard
final.
you. No, allowing at this stage on a junior applicant. These persons at this stage in the, we have heard you, we have gone your government. Yes, Mr. Biani.
Correct.
My application in short is application
It,
CAN
eh,
26.
92.
Can 26 in connection with what?
Connection with MAT number 873. Priyanka.
That is the board's appeal.
Lordship. Now, my case in
You are claiming to be similar to?
I'm not claiming to be similar to anybody. My lord, my case is completely different. I have been a victim of circumstances. And I can tell you, Lordship, in just in 2 minutes, I'll show you, Lordship, the documents. But I am a trained, officially declared trained candidate in 2014. My lord, I apply for, given a job in a Hindi medium school as a trained candidate. I am working there, made permanent. Now, my lord, this series of these bouts of litigations come in. Pursuant to this honorable court's order, well, Lordships are aware, everybody had to submit their documents fresh to the Central Board of Bureau of Investigation. I do that. In the meantime, I've written to the board several times that this is my higher qualification DED. Kindly add them in my resume. Now, my lord, this court directs that all the documents are to be submitted for fresh appraisal. I have submitted. Now, my lord, the list that has come out does not take into consideration my higher qualification.
Which list has come out?
The list pursuant to this honorable court's direction.
On the morning's matter, your lordship.
No,
was-
there's a difference. There's a difference. I moved a separate writ application before this honorable court saying that this is the problem. This honorable court, after having considered everything, disposed it off, sending me back to the government. That kindly consider this. The government has passed an order saying, considering all my documents and saying, yes, he is a trained candidate. His candidate and this higher qualification should be counted with the date of his joining in the school. Now, my lord, bereft of that, my lord, the list that has been published has gone down as not getting anything. So therefore, my lord, today,
No,
when
Mr.
ultimately
Biani, that is a cause of action which you will pursue independently. And we today morning we have delivered a judgment saying that because it was submitted on behalf of the board due to pendency of this matter, when the records were called for of
Lordship.
2016 selection process, all the records may not have been scrutinized properly.
Correct.
That is why there had been entry of names of say teachers,
Lordship.
but they have been marked as para teachers.
Over here,
We have said that this is the appointment letter, this is the scale he is getting. Question of taking any contrary stand does not occasion. Even if there is some error, that does not disturb your state.
well, that is my endeavor to point that out that this is the inadvertent error.
We cannot do that in this matter. You
No.
can take appropriate steps. You can withdraw your application and take.
Well, if your lordship kindly, when it's at least, my lord, says, falls from your lordship, this is the present position why I am aggrieved. That will help me out in my for the situation.
Aggrieved in the sense.
Aggrieved in the sense that
Mr. Biani, you consider whether taking away this to take appropriate steps will inure to your benefit, and if you find that it cannot do so, you want an order from us,
lordship.
then you please come back and tell us.
Very well.
But we are not on behalf of the applicants and everything. We have concluded the hearing. Next date we will start hearing the writ petition.
Well, before that, next day when his lordship starts, may I take 2 minutes of your lordship time after coming back that this is the position? Because today
I think after you see the order which we have,
I'll come,
today,
lordship.
it will be uploaded.
Lordship, I'll come back.
Tomorrow or day after tomorrow, I think if you go through that order and the contention of Mr. Biswas, I don't think there will be a problem.
Well, his contentions are always wrong.
Mr.
কবে থাকবে তাহলে মাথায় ও ডিটেলসটা কি সেটা কি কম্পিউটারের কাছে দেখে সেটা 19 মামলা তোর কন্টেনশনটা কি চাই তোমার ফ্যাক্টটা যদি জানি বসে বসে বলে নেবো
প্রথমে লিখো মিস্টার অনিন্দ লাইডি অ্যাডভোকেট অ্যাপিয়ারিং ফর দি
heterogeneous group, my lord, para teachers are also there, non-para teachers are also there.
Acha, Majilan, appearing for the appellants in MAT 1368, 1368 of 23
And my lord, MAT 913 of 2023, item number 97. That is, my lord, exclusively for para teachers.
913. Acha. In Banerjee and Mr. Chakraborty, an advocate appearing for the appellants in MAT 2188 of 2023 have concluded their arguments. Yes, Mr. Kumar, please tell us how many advocates are there for you?
Five or six, madam.
5, 6. Now.
Five. Madam, whatever. I'm just telling you lots
Now,
of madam.
who would be
Factual,
who would be the lead counsel?
but different issues are there. Factually, from the day one, I was there in the matter. I will argue on the factual aspect. Mr. Mujumdar is also there. Mr. Vikas Bhattacharya is also there. He's appearing for some cans and other aspect, madam. Four, total four.
Seven except can applications are concerned, there might be difference of submission. But so far the issues are concerned, it is the same. So
There will be no repetition.
No repetition. So chance of repetition.
The is going to release the matter.
Open access.
On 21st as fixed at we would request you to make it a bit concise. If so many persons, it becomes very difficult. So far as the app, we are just interacting in respect of we found the orders, Justice Sales order and said in those that one counsel would be hard representing them.
Well, that was
just if you have any objection, you let us know. What we are wanting to do is whatever judgment we deliver, it will be affecting all the participants in the selection process. Now this voluminous brief, now if we send them to the department for incorporation of names of more than 1,000 persons, it will be physically difficult. We can take down your appearance and your, as Mr. Chakraborty said, his junior will be there in the can. He will give his number, name. So at least that can go down in the order that we heard your contents also. To that, if anybody has any objection, we will be disposing of along with the main matter all the connected applications. But it will be really cumbersome if we send them back to the office and directly. So now we are fixing on 21st. We will be taking up hopefully on, if you can manage the dates, we can take it up concurrently and finish it off.
Very well.
There was a direction to produce, my lord, one resolution on the
panel.
last
Oh,
occasion.
Mr. বিশ্বাস, the 30th November resolution, which Mr. Sen was showing. He said
I've
that
seen your
it is
lordship
on-
last order, but since there was, I will hand over your lordship.
Please, yes, we have directed production of that.
I will hand over.
I don't know whether it will be, please produce.
Well, may I come back on 21st? If
21st,
your
my lord,
lordship
I will.
orders cover me or not, I'll make that submission. On 21st, if your lordship's order in 18 to 20 covers me or not, I'll
How
come back.
can we stop the advocates from coming to us?
Without praying, how can I appear? Lordship.